Good evening, everyone. Yema Obibia Akwaba Eba City Media TV. So this is Legal Hour with Lawyer Thomas. Sene debia no every Thursday you choose a topic back or I beka ho asem na ya pensem mu. Ni met here for kwan am my free ebisa mo questions. Enumpo so wo bibi na eche wadwene so a betimi ebie abra ya ebia homa no atom. Inti Lawyer Thomas yemo akwaba. Ene the beka ho asem employment law. Eno nti etifo yesrem se mobeya asono mwatie na mo ahu enyoma ekoso wo modwuma mu se yesisi mo se de bia nyo bi wo ho a mo wo kwan se munya enso ye mfa ma mo Lawyer Thomas enya atena na konwa so de na obebiebie nyoma so akye am yehu yensabe nkum ni nifa nti Lawyer Thomas se yebusa se the various forms of discrimination at work are near purchasing.
Okay. That's it. That church mu chino, but said the BIA kofo na omo social mo ka omo table from kwan. That might be to send you na mo at your say you are making so some nice moment. So thank you, Diva, for another opportunity for us to discuss legal updates with the public. Today we'll be looking at employment law. We'll be discussing the Equality Act 2003, which is discrimination claims. We'll also be looking at unfair dismissal under the section 98 of the Employment Rights Act 1996. So we'll go through most of these questions. It's going to be very, very interactive. After we have discussed most of these things in Twi, I will summarize it in English. And I'm sure that in the course of perhaps going through most of these questions, my language will be mixed both Twi and English. So those of you who are still watching, who cannot understand the Twi language, I'm sure that if you bear with us at the end of the program, when I give the summary, I will give very, very extensive summary to ensure that each and everyone who is watching can benefit from this program, because we are living in a very difficult times because of the coronavirus. Most employers are going through challenges, and there is going to be retrenchment of staff. People are going to have a lot of difficulties at the workplace. So this is an opportunity for us to discuss your right at the workplace. So, host, you can perhaps.
Like Thomas said, I say, question they can be me pisa say, so because direct discrimination na association.
Okay. Normally, na say say direct discrimination a bit to me. I see or a jumum and I say before I even fire before jumum. The TNS say a be or how compare juma. And I'm say be a one be a disabled. Na ya phobi na a jaw. Obi or o ye bibini. O compare juma na ya fabroni. Na a jaw bibino. Ebi or wonyam. Because of that, it is na ya foul na phobi fufro. Intino, say can't direct discrimination and play pino. So I say ya discriminating against you. I say unya obia or compare to that person. Now what me I can say. Menesa go food to winner and can say a human if it's a man I say minya. But what discriminating because what funny per way. And I'm say be a me to and I'm a year for. And I say be a me pregnant and I say be a me gender reassignment. It always ones direct discrimination. I can the employer not directly be discriminated against the background.
Okay. I say indirect discrimination, so no say
yes, say employer can say indirect discrimination under the Equality Act 2010. There are no patch and say employer non policies be or they are to indirectly discriminate against certain people. Because under the Equality Act, and you won't fair form of protected characteristics very discussed it. I don't want to jump this question, but the point is that indirect, just say police now, they are two discriminating against certain groups of people. And indirect, because indirectly, you are the police in CBI say, will be a shatter, they say. It be a way will be a satire and no sharp because of religious belief in never affect them. Internal indirect discrimination because of employer and the police or the other two jam. It don't know here will be out there compare as compared to direct discrimination. I say he will be out there compare say we not if you say we're treating more favorable than me. But we know it is because policy no and indirectly discriminate against certain people. Who are company be a policy or the abano. Be a or my say be able to do some age compulsory be a retirement. So and I be able to do some age you might some of the man and I be on PCB you would in between there indirect.
Not just a direct discrimination there would do any who say any who say any being the indirect in the say and then I'm changing
I say yes policies indirectly affecting Kofo because the way policies now indirectly in the
favor
okutakola ketua sanka will make sure say employer make sure say because of that ntibia Kofo money ba no be mo abia abanopa na no bia ba be wi akakra. And this Senya Kopase, and say I think I had somebody who called me about something of that nature. Senya Kopase, employer and a kinchina or Silvano Branca.
It's your consider
also, and I just saw discriminate against pregnancy or somebody doing maternity or.
Okay, so you can say harassment and so not just as I just say.
Yes, the TNS say, you can't harassment. And pre-pay adwuma mu no be na obi wo a na ye di nani saa na because ya depression. So which is near bi unwanted conducts bi or your bar be a supervisor who do no ma who do adwuma mu a obi a betimi ama workload bebre just because be a or make advances at you wa object intino says na if you obeka or hide behind any feelings to treat you unfairly. So so anything that affects sanipa con detriment or unfavorable treatment because of unprotected characteristics, because of your bar and because of your disabled. It those things harassment. Bu onoma and I'm so be bia would adwuma because the manager and be or you the one and a casa and I be out me man all those things aware it could amount to what they call harassment. Yes. Okay,
that's it. So my next question, how can victimization occur at workplace?
Yes, and normally victimization is where, for example, things have been said against you that perhaps sometimes untrue. If you are crying, you man never be koso, and I am kuli, and I wakoka, and because of that, one person weakness or not, and sometimes those conducts that affect the dignity of that person or makes the workplace hell for the person, probably because of the characteristics. Because when you get discrimination, we are always looking at some protected characteristics. And sometimes there are minor issues or he's being victimized. But so also you are being victimized, you need to go further to put yourself in a particular protected characteristics which is it because we are disabled and is it because we are bibinity and is it because we are gay and lesbian, and is it because of the fact we are Christian or Buddhist, your religion or belief. This time vegans, for example, they take them. You need to put yourself in that protected characteristics. Then you can then rely on any unwanted act, anything that affects dignity as victimization.
Okay. Can discrimination arise from disability before one is given employed?
Yes. The TNS in Bripune if we say discrimination, or care, a brow word to me. But sometimes discrimination it may arise even before before. For example, under section 60 of the Equality Act, most of the times I will fill application form or maybe say we are disability and or a dear nationality, race, sometimes or maybe say or religion and all those things. And if you are no more, me find say Marco pay Juma. Na Juma na Marco pay no. As long as our information say be any background, we are more qualified than no. But I'm say be no ye bruni, and I be aware disabled, no ye disabled no. Even though you have the same qualification, and nuntina be your more fan, which means in that case, even though you young foul, but say now we to make claim say or more treat you unfavorably because of, for example, your race or your disability or because your age. It cannot be to me arise even before you are employed.
But in that case, no, you need evidence as well.
Well, normally, say.
Why during the year, sir?
Yes, if the tenant say if so allege say this is what has happened now, then the employer no has that burden to prove say and this and they say if the employer no, as we say this case is in the tribunal and as employer not to me and convince the judge and they say it be a different reason to know far will be rather than we are race and I be our disability in TIS or year for and I say be because of age and because it be our page man when you mutino and our for and I want to me and convince that in that case judge will find it against employer.
Say Juma we dear yenya fa okra na ochuma swing. Na ye benya fa employer say osro dada ana.
Yes, say if you are sometimes the tenant say we say Kuma saying especially in CBA BPN and answer from certain background and pre-P you are Juma penny idea it's always very difficult. But sometimes if you look into it Ube say if you cry na can say a foul. So I know it's difficult to prove it sometimes because obviously but at least it's a claim I'll pursue is available to people who want to pursue it, and that option is there for them to pursue. And remember, if people continue to do that, then I'm sure that employers will set up, and each time people are making application for work, because sometimes on which way Equality Act on Section 16 most of the time, some of the questions that employers ask, I as employment lawyer, people who are formed now, my friend, the nature of questions can be bizarre or clearly might give an indication say there could be a discrimination. So, so there are a lot of factors that could be even the application stage questions that on be bizarre near and information they have elicited. My whole point to the facts they are intending to discriminate against particular group of people.
Okay. So which categories of people are entitled to reasonable adjustment at workplace?
Okay. The TN say they're not mechanical. There are people in these protected characteristics that are protected by law. For example, Obioye disabled. So if, for example, obi a adwuma na say ebi a obi o start here adwuma na onye disabled, but okoye adwuma do baby no na wa be disabled.
Okay.
Until disability, and I want to explain it here. And you know, say adwuma na wo yare for 12 months or more, you are categorized as a disabled. So sometimes, you know, disability is not your physical inability or your immobility. A bit me about say or be a depression. So a bit me about say, so as long as why is sick, you've gone sick for almost a year or more, no, you then become disabled. But the point here is that when we say employers are in business to make profit, and when people for one reason or the other become sick, they are not happy. So they find a way to sometimes to dismiss those people on what they call incapacity grounds. Yes, or money fit to do their work. But I know that people in this situation, they might not know that they have a right, that once they have been sick for more than 12 months, they fall within the protected characteristics under the disability or the Equality Act. That means employer needs to make some adjustment, and if they cannot continue to cope there, that means say more alternative jobs and more transfer so all those things are what they call reasonable adjustment. Be a or very long distance. If there is a branch near the person, which means okay, because of that or this branch, so you are making reasonable adjustment for that to accommodate that person with that disability. Go bit me about so be a phone hour for all these people.
So in this case, doctor nebema why am letter say where you disabled, and I say lawyer nebema letter.
Yes, so the American, the law makes it very clear, say automatically. So if you have been sick continuously for 12 months, you become under the Equality Act, you are classified as disabled.
So you have to prove it.
Of course, obviously, say we are rare. Sometimes the doctor will say to do now because some people can be suffering from what they call depression, and though there is no physical immobility, so but mentally, do a good moment. And function. And you are right. Doctor will confirm that you are sick. But the point is that, so if you are sick for that matter, not just as long as the sickness has subsisted for 12 months or more, automatically you become disabled, and that's when the reasonable adjustment and all those things.
And it's a COVID by a card media, qualify for. Because in the area in them, and then the doctors are confirming my internal count.
Yes, say COVID or what you want to fellow, because what I feel I don't get the same as being sick.
Nothing I need you one near Shedem.
Yeah, why you about because you're a fellow, not because you
lawyer, that's it. If I say, besides, what will you consider as pregnancy and maternity discrimination?
Okay, the attorney said, who do one-on-one. Employers who say, yeah, the attorney said, so being a man. And I'm sorry, I'll go for maternity leave. Again, Biofi, maternity leave in the bar, because of your work, but we hear what they call reasonable adjustment. People some accommodating in certain areas that are very with my year, like Germany. And say, a cobase or more make those provisions now they treat that person unfavorably. Now, and say they are discriminating against that person. For example, there is a case I was dealing with. Me find say, or more redundancy. redundancy no more, which means a kofo adwuma no akofom to omo yi kofo ni bi adi into omo ye selection no more ye no ebi a omo akofa ono because ono no onyam so and no nom dey cancel the selection no more yi na fi adwuma nti no sa no so oje redundancy pay no kwa na obitumi claim say he's been discriminated against, he's been treated unfairly because of
the pregnancy. Yes. Can dismissal from refusal to take COVID vaccination amount to discrimination?
Yes. A very, very good question, because obviously, we are in the COVID era, even though most of the restrictions are no longer in place. But it's still the case that currently, there is no law apart from the Health Care and Social Care Act 2003, which makes it compulsory for those working in the care sector to take vaccines. But even that, they have exemptions. Exemptions is, again, if they can prove that they can take the vaccine because of some disability or for some other health reasons. So they say, so even with those which is compulsory, you realize that they have made exemptions for them. And the Sekoba said, for example, for whatever reason, my country said it is only in that healthcare and social sector is compulsory, which means that other areas there is currently no laws as employer for someone to keep vaccine. So if for whatever reason, and I'm not saying say man go for ain't to keep vaccine, that's not what I'm saying. I'm just giving my view of the law. If for whatever reason now person will take vaccine, now employer like I said, because one take vaccine, obey you idea, that could be discrimination. But you need to show why you feel say you've been discriminated. Do her because of your religious reasons. When say I think it's almost more Jehovah for someone and your blood transfusion, I don't know. And obey religious religion. Obviously under the Equality Act, sometimes it's not just religion, it is even your belief. That's why vegans and all those things they can now claim say they are discriminating against them at the workplace. So if either you're religious for religious reasons or for your belief, you can take the vaccine, or because you have some form of disability. And if for any of these categories, or because you are pregnant, for example, all these people, you need to first fit into the protected category, which is what I've said: pregnant people, those with disability, and all those categories of people. If you fall within that, then you can claim, say, if you didn't take the vaccine because of that reason, it means that they have discriminated against you, and then you have the right to make a claim on that basis. Yes. Okay.
So, what is unfair dismissal?
Yes, it's quite broad when we are looking at dismissal, whether it is fair or unfair. Fair. Yes. The first point is that the distinction I'm going to say with discrimination, you started discussing my explaining say who occur human choir foul I'll be to make discrimination. If I was starting a Jumano or starting a Juman assembly, you'll be to make discrimination. And three, you can even claim the discrimination compensation whilst you are still employed. It is obviously be employer now are discriminating racially against you. You can claim for discrimination, get your compensation, and still be there working for them. With unfair dismissal, your compensation will come from after you have been dismissed. And there are a lot of remedies, but I'm going to explain the unfair dismissal aspect. First, or the first point is that currently, before I'll be here entitled to unfair dismissal, he's a one employer and a for minimum of 2 years. In Timbesan go for a and intina sometimes no and prepaid to do our year now I have 2 years na be also per holiday na be employer na kan say holiday na open no men farm e bi okoya na mo yinadi because that particular time na on do 2 years no say yinadi na ya fa kwan papa so kwa mpo na yedi yinadi a e bi a using ya yedi yinadi na boss e kon but ene kwa mpo no on to me and found court tribunal. So I say I'm confessional say before I wait to me I claim for unfair dismissal and I say why you 2 years or more. Another point is that for the dismissal to be unfair, no, there has to be reasons. For example, one, a bit me about say employer and on policies what they are in place, you know, when so and or you would go out on the policy necessary. Now I'm follow. It is say you would dear so say they are now yeah no. Is it in accordance with employer and the policy now? Say if it's not in accordance with employer and the policy, then it be now or who rights will be with. But if it's in accordance with the policy, not so or you would dear, like just says resistance could be unfair on that ground. 2, ebu okwa na policy no wa ma wanya aware. Ejumebu ono ma uro mu a so mo ye induction and bi o mo anche da anye o mo ama handbook ni ade. Ebi okwa na o mo changes o mo send o by email. You are not aware say bia nsembi niam bia asesa wadwuma mu ono mo. Nti eno no sa na say bia akwa mistake because we nim na so mu yi wadi again second read could be unfair. Third reason is, for example, say employer no before we go be no, and it happens a lot because I'm going for so. Say follow proper disciplinary proceedings, which means one. Say you are going to be in again, or first or man and reason to your pursue in it. 2. So inviting people for what they call investigation meeting. No man can or also can the side of the story. And 3, say we make a decision based on proper investigation of all the issues now we're taking into account. No? And 4, the background now investigation on any obey decision, say different. And sometimes when you be an employer and anyway, but now I'm follow that process. No? And also, another grounds of a dismissal no, are unfair.
Okay.
And these are various reasons of a dismissal from the workplace. So the employer should be able to dismiss within the reasonable band of, based on proper investigation, the reasonable beliefs that whatever allegation or whatever he feels that the misconduct that the employer has. Employee has engaged in really occurred.
Okay. Yeah, that's it. So, who can bring a claim for unfair dismissal against employee?
Yes, I think as I was explaining, it is only those who have been employed for 2 years. For 3 years or more. It's only those people that.
What is the deadline for bringing unfair dismissal and discrimination claims to employment tribunal?
Yes. A break, if you are on my unity, if you are common opportunity, say, or your way, or pili be an hour pili. But the point is that there is always a deadline between the claim no about a court tribunal. So deadline is always 90 days minus 1 day, which means that we count 3 months and now you 1 day a few. In the SO claim to employment tribunal. But currently, compulsory say before what do we claim no be call employment tribunal. So what they call ACAS. ACAS is considerate a year or mono to be say or money employer no BT as to try to resolve
the issue.
So more to me resolve the issue now. No mama certificate. They said the last 9 years discuss child care who call for mediation. No mama certificate now based on that certificate, Now they are called. Sometimes people who are ACAS level now, an employer now who say be a mistake, be an resolve, at that stage.
Okay. So what are the remedies for unfair dismissal claims?
Yes. So people are chrono. So if you say you deny is unfair, remedies, most times, say just one remedy, which is the compensation. But remedy of compensation, is just one, which means say all the employer no court employment tribunal on be trial compensation for your loss of earnings, or normal compensatory award for, and then your future loss of earnings. So sometimes it will involve a lot of money. But there are other people who do normal mortgage. So you can also say that it should be reinstated.
Okay.
So it is one of the remedies that you can also be reinstated and get your job back. But obviously most times when people go for the remedy for compensation, because by the time when we do employment tribunal, that relationship will not break it down irretrievably. So they will not be interested in even working for that employer again.
Okay.
So that's why most people go for the compensatory award. Yes.
So what are the remedies for discrimination claims and also?
Yes, discrimination. Say an American. The remedies normally is when you suffer discrimination, you suffer an injury to your feelings. Mm-hmm. So the remedy is quite substantial. For example, if you want you would one a bit unfair. That's another ground for your claim. A bit discriminatory because we are good ways. Unfair, not to say that I can be a man follow employer and procedures in terms of disciplinary and all that. And then the discrimination is the fact that we are because of EBB and our disability and all those things. And when it comes to discrimination now, apart from getting the compensation award, and you also have compensation for your injury to the feelings, which currently is start from about 9,000 for those small cases, and it goes all the way up depending on how serious was suffered. And to go on because of discrimination, it be on your depression, so the court will take all these things into account and then make an award for the distance. Yes.
Okay. Yeah, Thomas said that answer na yebeto so ama waka brofo achechi mache yinuanom omonte Ghana kasa no yebeko break akra nti etifo yesem montwen e try ho abasisia. Yema obibia akwa ababiem eba media TV so sene da ye no ya wada bia yehia na ya fa topic back ne apensen mu nti ene ha yehia ya lawyer Thomas Atenasi na jeso mu sene ni abre emraso se wo ka profo amonte Ghana akasa no muti ase nti lawyer Thomas obetimi summarize ensema ya kan nyina so that obibia won take Ghana Kasano and also Enya Kwenya at TV.
Okay, thank you.
You're welcome.
Once again, thank you to all of you who have been watching us every Thursday evening. It's an opportunity for us to meet, to interact, and to always give updates of the law. I know that most of us have very busy schedules. It's always difficult to be reading about all these things. but few minutes of your time by listening, you can learn a lot through some of these programs. This program is brought to you by City Law Solicitors, and every advice we have given here under our disclaimer is for guidance only. If for whatever reason you want to rely on this advice to pursue a matter, it is advisable that you seek independent advice. If you don't have a lawyer, you can also contact us, and then we'll be able to deal with your matter expeditiously. Today we've been looking at two areas of the employment law. We'll be looking at the Equality Act 2010 and then the Employment Rights Act 1993, specifically Section 98. And throughout this interaction, I've been looking at various forms of discrimination. Started by looking at the various protected characteristics under the Equality Act, which is race, religion or belief, sexual orientation, disability, pregnant women or those on maternity, sex, age. So we look at all these protected characteristics. Now, when we say protected characteristics, that means that these areas are areas that people can rely on it to bring a claim for discrimination. Now, we also looked at victimization or harassment and victimization under the Section 26 of the Equality Act and the Section 27, respectively. And we said that at the workplace where there is harassment, for example, unwanted conduct towards a particular protected characteristics, then that person can bring a claim for discrimination on that basis. Or where somebody have been treated or have suffered death treatment, or where his dignity has been affected adversely owing to the conduct of one of the employees. And the fundamental basis for this claim is what they call vicarious liability, which means that employers are vicariously liable for the acts of their employees. So when these occurrences take place at the workplace, or these incidents happen at the workplace, irrespective of whoever was the perpetrator, as long as it's happening at the workplace, then that employer will be vicariously liable for that act meted out to the victim, which is in this case the person who is claiming that he has been discriminated against. So we looked at these areas. We looked at also how discrimination can even occur before one is employed. Again, we established that under, for example, direct discrimination and indirect discrimination. With direct discrimination, we said that you must always have a comparator, which is somebody that you are comparing yourself to say that you've been discriminated or you've been treated less favorably than that person. I know that sometimes I get cases where people are alleging discrimination, and then by the time you take them through, there is no discrimination, just that he's having problem at the workplace. So normally, if you are alleging that you have been treated unfairly at the workplace, it doesn't end there. That does not make it discrimination. If you have been treated unfairly due to your protected characteristics, which is whether because of your disability, your race, your sexual orientation, your religious belief or your belief, in fact, it is only on those grounds that you can reasonably conclude that you have suffered direct discrimination, which means that that person have treated you unfavorably compared to the other person who is not disabled, or he has treated you unfavorably compared to the other person who is either black or white, your race or color. So that's about direct discrimination. We went further and looked at indirect discrimination, where the policies of the employer indirectly discriminate against certain groups of people, again with protected characteristics. It could be those who are pregnant, it could be those who have disability. If the employer have not made the workplace quite safe or quite conducive for those with disability, then that employer is indirectly discriminating against those with disability. If the employer, for whatever reason, has put in place certain policies that discriminate against older people, that is indirect discrimination. That person doesn't need to have a comparator. Indirectly, the policy is discriminating against that person. Or it could be that women are discriminated against because of certain policies that is in place. So that's about indirect discrimination. We went further, and then we also looked at unfair dismissal. Now with unfair dismissal, the starting point is that you should have been employed for at least 2 years. So for those of you who have been employed for less than 2 years, you must be careful at the workplace, because most of you know that the least mistake, the employer will not hesitate to dismiss you, because you don't have the right to bring claim of unfair dismissal at the tribunal. And for that reason, even if the reason for dismissal is unfair, you won't be able to bring a claim against that employer. So the starting point is that you should have been employed for 2 years or more to bring that unfair dismissal claim. And then we went further to look at various scenarios where dismissal could be considered to be unfair. The starting point is, for example, if the company has not followed its own policy. Sometimes they could say that when certain misconducts occur at the workplace, they might even give a warning, sometimes final warning. Perhaps they may not follow that policy. They could move straight away and dismiss you, outright dismissal. That means that they have not followed their own policy. So that dismissal could be unfair on that basis. It could also mean, for example, where the employer has failed to engage the employee in disciplinary proceedings. It's obviously required that when it's alleged that somebody has been involved in misconduct, he must be given reasonable opportunity to explain himself. He should be invited for a investigatory meeting. This meeting should be chaired by a management who is going to be different from the person that makes final decision of dismissing. If the same person does both, that dismissal will be unfair. Or if we didn't subject that particular individual through that process, that dismissal could also be unfair. So we looked at how dismissal can be unfair under the Employment Rights Act. And then we went further to look at various remedies. We looked at, for unfair dismissal, you could have compensation or you could have reinstatement or re-engagement. And then for discrimination, we said that you could even claim compensation and say remain in employment, which means that you don't have to be dismissed. Sometimes some claims of discrimination are brought jointly with unfair dismissal if the two have happened before the person decided to leave. For example, where there is a constructive dismissal, the person has resigned because he feels that he has been discriminated against. But in most cases, you could still claim your compensation and still remain in employment. And normally this compensation is based on what they call injury to feelings. So that's about compensation for discrimination. So we looked at all these areas tonight. Perhaps it's now time for the host to take us to the remaining.
All right. I told my head, so it's me a cambrofo. I teach him. I want more to brofo also at Yassi. And I've embraced to see a baby out manato. Initiative for yesterday will be out, will be assembly beside a farm, and I say, will be bisano. Number non ewo screen so yesterday mo free. Na mumbisa bite bibi chire wadwene nsama ya chichi mi ebia na adwumam ya ye obibi a wantimi anka ana ehye wo so wantimi anya obi ani na ani ho komo ene yatna akonwami yatna se pray ni chichi mu ni hu di obetimi aye wa adwumam ti yestrem we twem. Hello.
Oh, yeah, hello?
Hello. Good evening. Me Pacho,
Hi.
Koso.
Can you hear me?
Yes, please.
Okay. My name is Joe. I've got a couple of questions for Lawyer Thomas.
All right, go ahead, please.
Okay. The first question that I want to ask is in relation to a claim that I think is called unlawful deduction of wages, whereby if you've not been paid well or there's been a deduction to your wages at workplace, you'll be eligible or you can make a claim for that. Can lawyer throw some light into that area to know when we can make such claims and where we can submit that claims to, please? That is the first question.
Okay. You can tell us the second one, and then Thomas will handle it.
And, my second question is in regards to discrimination.
Okay.
So, before you can do discrimination, you can file for a claim based on discrimination. Would you need to be with the employer for 2 years before you can do that? And then also, because I've had similar experience in regards to discrimination, and I think it's really, really difficult to file discrimination because the court takes a lot into consideration. Sometimes you'll check and see if people or certain individuals have passed through that same category or same area from the company, or if the company have failed to obviously adhere to the discrimination or to the equality characteristics, as you mentioned. So I just wanted to throw a little bit of light on the discrimination part as to why sometimes it's not straightforward with the court, but I mean they do require a lot for them to evidence, because in the situation or in my case of what happened was they asked to bring evidence of people that have been treated unfairly by the same company, and failure to bring that didn't result to positive news. So I just want to find out why is it that they always look into that, but they can't deal with the individual as a person, but they always want to compare that to what has happened previously to other employees, other people in the organization. Thank you very much.
Okay. Yes, thank you.
Okay, let me answer the question in turn. The first question is unlawful deduction of wages. And the second question is about the difficulty in bringing discrimination claims. And I think indirectly he was talking about direct discrimination because they will expect you to. But with regards to unlawful deduction of wages, again, this claim also has a deadline. So if you are seeking to make unlawful deduction of wages, that claim must be made. If he's going to the employment tribunal, that claim must be made within 3 months minus 1 day. The process can go through the ACAS, and then eventually ACAS will issue a certificate and it go to the employment tribunal. So that's the first remedy for bringing a claim against the employer for unlawful deduction of wages. So if you pass that 3 months minus 1 day, then that person is going to have difficulty. But going beyond that, if that person was not able to make that claim within that 3 months and it has passed, that person have a right to make a claim in the county court. Obviously, if you owe someone, it takes about 6 years. So the point is that once you are claimed to the employment tribunal is 3 months, if that 3 months pass, you can make a claim to the county court and say claim for the same unlawful deduction of wages, which is more or less being treated as a debt. So these are the two ways that you can make a claim for unlawful deduction of wages, either to the tribunal or the county court. Now, with regards to discrimination, I share his frustration. I said that it's always very difficult to bring a claim or to be successful in a claim for discrimination. The reason being that it is these same employers that produce the bundle for the hearing. Most of the documents that the claimant is going to rely on is in the possession of the employer. So it becomes quite difficult. And as you were saying, sometimes when you have a clear case, if it is direct discrimination, as you were saying, then of course you need to be able to show that that person was treated more favorably than you. So if you cannot show that, then presumably you might not be able to succeed. For example, if you are working with, let's say one person is black, the other is white, you are doing the same job, they are paying the other person more wages, okay? Those who are on salary, maybe he's getting 21,000, you are getting, for example, 18,000, or he's getting 3,000. You can say that the fact that the two of you are doing the same job, and the fact that he is being paid more than you, it means that there is clear evidence of what? Discrimination. Because of the race. This is the only reason why probably you have been treated less favorably than that person. So, if, for example, you are saying that you're also relying on, for example, reasonable adjustment, the employer has to first show why he could not make that reasonable adjustment for you. So if the employer can say that I can't afford to keep you to do the same job or to give you part-time job, then of course, even if you are within the protected category, the employer can still dismiss you, as long as they can show that there was no possible means of keeping you or making that reasonable adjustment because of commercial reasons. So these are some of the reasons why, that is why it's always advisable to seek proper advice whenever you are bringing some of these claims. Like I said, I had somebody who phoned me, he said he has suffered discrimination. By the time I went through the whole advice with her, I found out that he had no claim. He just had difficulties at the workplace, not necessarily suffering from discrimination, because there was no comparator, there was no policy in place that was discriminating against her as a black person. So there was no discrimination. So that is my answer to Mr. Joe's question.
Joe, I hope Lawyer Thomas was able to explain things to you. If it's not clear, you can still call back. It's here for you. You go swear to her channel. Wait me on number screen so no afraid. See, be chill, Junior. Okay. You could say I try am be afraid. Wait me aka bibi kakra say emra no say na ekọ bibi asesa wo say na otwe ekọ tena fie bibi asesa wo ma na bibi foforo ba ana say sika bi wo a covid ekọ ya o so mo betwitwa benefit kakra mo de mai mo twitwa mo mbesa mai bibi foforo bi ana so wait me aboy no so kakra mai ya so that you be hu sika kra umutwa ekọ friend say fellow no kra na omode so yeso kakra na omufie bi.
Yes, as I think I did
last week.
I think about 3 weeks ago, we were on the same employment law. I think in September this fellow will come to, and most people are already familiar. Immigration, the update there is those who are called extended family members. They are going through a lot of difficulties, and I'm sure there are a lot of challenges, but obviously, irrespective of that, the current position is that if you are a extended family member, then, for example, if you are saying that you are financially dependent on that person, then it has to be continuous, which means that there shouldn't be any break. The tribunal has just had a new case which has confirmed that that dependency or whatever financial dependency or in the same has to be continuous. And normally under the EU law, that there shouldn't be a break of more than 6 months. So I'm sure that people may not be able to make those applications, but even those who are seeking to renew their applications, Home Office may be seeking to ask for documents along those lines, so they should be prepared. So that's the update that I have for those EU extended family members. And then those who are also still seeking to make applications, it's still open to them, provided they can give reasons why they didn't make it earlier, as long as their relationship was formed before December 2020. And I'm sure this may continue until about December.
As a Thomas, who can bring for the country, Kakana, yes, I brought from the internet, yet I say, girls who put Togo Susana, now a fire soon be intimate, yes, sir.
The TNS said an American, a uncle fire for more extended family members. So even though EU law, no, as a very year, but near master air course behind the scene. Normally, as a family member, just a be, I would say, if I can honor.
Okay, 1 minute to be fair. Hello.
Yeah, hello, good evening.
Good evening.
Me Pisa lawyer and Kafra.
Me Pacho Bisa.
EEC Mrs. Pama adoption. Na first on a more refuse to no. And ye call court.
Okay.
Ye call court no. And omu e cast and my say or omu the amankola ye fama.
Okay.
After and omu cashier say yema and grana for omu passport and British Embassy of Ghana. I say and grana the omu the koi in omu the koi did there 3 weeks, 3 weeks time now. 31st, that was 31st June. And there's a movie in Mukra. It just a movie Mukra, no more time less about it. Sincerely, almost it's almost never from our movie. The best of the Italian says so, and it's may possible say, almost after court, a month and a deep now, almost from a passport of bra, almost the call embassy one, Sana, 31st, the Bruno, almost. But you almost can and run say, a bit very possible, and I say, you bet me
Yes, I'm familiar with question now. Bisana. The TNS say, who say, what share EU law now? Obama will be up to June 2021, so on applications. And we share the 31st December 2020 now. Or more year withdrawal agreement. Withdrawal agreement in a year agreement UK and EU member states no ewo. Emuno omoka say saa nkofo na omoye EU family members no. Omoma omokwan na omonye omo applications up to Sata me a dream year queen where my son is standing. Now, Wiki have for no be or more EU settlement we know. Or more ye extended family members no if you no me or mufi muno. Not just say Sata no kono. We are extended family member now we application now and people no more refuse. But difficulty who free say. So we na omo allow appeal no. It's under the EU regulation now before December law there no. Not just say no sir, not just say. Sa card no some issue na complete media to up to June 2021. After that no so when your settlement scheme na won't mean find two coin. So that's the first challenge here. But there are two issues making a decision we illegal. One is withdrawal agreement no go contrary to wiki for emrana or more person de edin kofunya no. And two we share Home Office for so practice directions na your issue na or much say obi court tribunal going to no money case say omo enforce that decision because obviously the semi court now say o enforce decision na say who here say can be court no, and it means se court na se omo fa mo so omo fa kwan so bi so na omo de mo no mutumi ba but akwaya ade a omo mpese peye it looks like one hwa ade we no ebe call for what they call judicial review on 2 grounds that 1 omo breaki withdrawal agreement no and 2 they are not following their own practice directions such as sanka one winning case no sanka omo de man so but I understand say apart from the American, my experience just said there are few challenges with those extended family members. You know. I hope say what you say.
Yeah,
you know, say, oh, a lawyer, what the salad and about what children. Now, what was only lawyer now per se, I'm sure say we can find a way because I never one or was at TB and I've heard a lot of people going through those problems. You know. Why?
Now I say, number and the screen is here now.
My number no 0 office number no 0 so what pen a bit natural why?
Okay, me natural.
Office number no 020 33 55 0782 yes
okay.
And then Thomas
alright okay
well into which Facebook now here no so or share so as a YouTube and Facebook now here or share through text and I was one of my say your email address and office number and my mobile number in answer or no why
yeah,
but and that's the way.
Bye-bye.
Okay, bye.
Okay. I say now or limited time as I say application and whatever I says you know.
Yes.
And that's we delay and I'm
yeah, you are very, very intelligent.
Because so tell you as I'm near me up as a breast and I feel now you're the amount crown and I assign by all means some of the strategy we be sure what because the deadline.
Yeah, say you are very, very intelligent. Yeah, say and prep no so go for judicial review near there now. Yeah, protocol is they will make it within 3 months. So, and to wait a
man was one day in
there be with government tribunal. And to wait say now, as some now basano, a better so initiative so go for judicial review because there is an action I want trigger by not doing what they're supposed to do. You know, a better so that within that. I'm saying you know, people take that one for granted. Why have time of a castle?
That time it's here for your castle in any train, Muslim phrase, the beach white junior. Yes, I'm free. Thomas, I didn't a I won't change you when chemo. Now, be in for NCCA. Send any dick cano. Now I can't run or send a coso.
Yes.
Yes,
for example, that's what I was saying. Because of all these things going on, it is important simple for people. We say Nipani extended family member. They expect say extended family member no. So dependency, I would say, for now sure on the other, continue. We are saying we be able to do baby question, but maybe I can say for be about just in the back on now that's social. In America, say based on case, new case on the standard family members about tribunal is important. Say go form what's the issue. Mom can say be a court to bua and I say be a Germany pacono and I say be a there's some way to show say there is that continuous dependency, financial dependency. There's some more that's what you say. If you feel not here, so making sure say people address near the time beyond. Ono sunya be just or to fear na ocean. So now manana and say we should say because sir dependence in break here. One shall not or any evidence and you say what that's a show, especially more these challenges.
Okay. That's it. Yeah, that's Thomas. Inti you be try kakra you no be afraid. And I say bibi kakra bibi o ha pesa o ka kire ne. And it
yes, I think for this time around, that is it. But obviously, I am flippy and candy politician once, but there's some go for so yeah, very careful because these days, again, cases about tribunal shows first on Ankabia, he be deported now so a colania there sometimes, boy. But this time, if the relationship is not stronger, you could say be deported even if you have.
Hello.
Hello, good evening.
Good evening. Me pacho be low our fidie no on time na can't at the county our frame me pacho. Me pacho I. There be me tea wa ha.
Oh, okay. The patrol, Mr. Fairley, the lawyer, my sister is sick.
Me pacho there is still echo there.
Oh,
yeah.
But I chief you phone why?
Me pacho.
Oh, okay. The patrol, Mr. Lawyer say my sister is some brand new for Oma 2.5 weeks. Maybe one child 3 times, now we'll call 4 times now. Which now will British child out. Which can be the and brand for indefinite.
Okay.
I just wanted to find out how true it is.
Yes. Yes. Partly true. Partly true in a sense. Currently, based on recent case, it allows go for more British or more primary carers of British children. Go for who say I need to set this record straight. First and foremost, before I were entitled to sign indefinitely, which I will explain what I will be to my entitled to it based on the fluidity of the law. One, I say Akolano, what if 5 years or more? Because obviously you should have been a primary carer of the child for under EU law 5 years or more. We into where by any 5 years, it be our yes application unya sign definitely because Obano under the law unya primary carer for 5 years. We are if you want to case in Ankasa na Yigna so there yes as and brand applications under the EU law. Home Office for Emma Omotias yes say be challenge decision. Into Munyan for practice directions MI or directorate instructions I can say be our application and say time say number decision and see number. But it is true say it's open to people some best application. Because apart from the fact say true some to be application, more make a decision there and then because you are still waiting for the outcome of the final challenge person put it across. And we share consent order and so what judgment in Musa and also can say or more year challenge in we are on for some years application another 6 weeks to do the application. Which means as a lawyer, you have to keep on monitoring to make sure, say, case in the barrier 6 weeks from that time over your application, But it is advisable, say, go for your application, Say the bear the more and there's a cobase, time the banner the more, or the demo, the bema. But we are there, and yeah, the bema automatically because case is very fluid.
Yeah.
And my final advice and says, we just start applications and brand new application now open indefinitely now. Making sure say federally to remain so be renewed because law judgment makes it clear say who to me application now I sign your leave to remain there so when you leave remain and say we get to na says I'm brand new ko say finally the home office for money na so much farm am go for na why you na be illegal if better say go for be share no so why so that is my answer to the Zambrano question.
Yes. Thomas said that CBB nti yeguso aye twen etie my friend no na ye bekoso a discuss enioma ye koso enioma enframa ye fire on okroma CBB koso a because I cheche mo aboboy so
say na me kan obvious say go for share so the one good thing about excuse me say I can afford CBB now and pay once but or more for example I'm sure it's a common knowledge out there but still now I say bonko because we shake kisisa about tribunal one more so come say for example we indefinite now you're British we are born and do 2 more than 1 year automatically it may recommend say you should be deported so and you know first no nanka se bia o akola okruma say it may claim say oh akola no one is not the other but this time no side relationship if it's not stronger even if akola they could say deport you because you can see that it's happening to a lot of the Jamaicans for near there they may perceive you for share and so na ya share on sui na niama ade be ko ha mu no ya enye careful because it is real we visit be or krata anti no or ya they are on dream home ko chiri but so on your British now that's kuta Ghana passport now or indefinitely make sure so we say you 2 na say more than 1 year you are liable to deportation order anti another update and percent go for a senator.
Okay, yeah, Thomas. Yeah, that see bebre say and so ye frel wan twetwe na ase obo modern ai ba be kan ho abechichi mu aba ye hu say adwumam etoda ye discriminate yen enso ebu okra ye nim ebi ye direct ebi ye indirect enyoma ekoso wa adwumam bi ho a ye nim kra se ye yesa na ye de no ane se de yakwa adwuma na ye adwuma nti ene ama ye hu ye sabe nkum ne nifa se bibi to hawo akwa adwuma na bibi hawo adwena wonti ase a ya Thomas number go FDA so free na ka bibi hawo che no oncheche mu me ntru bibi a nti sene ye nkasa bebre no ye de ya no ebesi ha na ya congratulate ye mba eni ye namfofo abusuanfo nkwem nkra na o mu wie GCSE any O level no ye mo bibia etrinkwa congratulations ye besia na o chesene ye damase